Members, the next bill on the agenda is House File 3350. Chair Pinto. And I believe, Chair Pinto, your motion is to recommend that House File 3350 be placed on the general register.
That's correct.
And you do have an author's amendment, the A1. Would you like to move the A1 to get the bill in the shape you desire?
I would, Madam Chair, and members will see it's just a technical fix.
All right. All those in favor of the A1 signify by saying aye. Aye. Opposed? The A1 amendment is adopted. Representative Pinto, please tell us about your bill as amended.
Thank you, Madam Chair. Members, House File 3350 conforms state law relating to the circumstances where someone convicted of a domestic violence non-felony is prohibited from possessing a firearm to match up with the federal law regarding that. In conversation with staff and with GOP colleagues, it's to a certain extent this is really clarifying Minnesota law even beyond conforming to federal law, because there's some potential confusion in the way that state law is written. This again would confirm that that someone convicted of a domestic violence non-felony would be prohibited from possessing a firearm to the same extent as is true in federal law, and would hope to have a member's support for the bill.
All right, and I don't see that you have testifiers, and I don't believe anybody from the public signed up to testify, so we'll move on to members' discussion. Representative Bliss.
Thank you, Madam Chair. I thank you for this. I don't usually thank authors for bringing a bill, but I think it's a good idea. I would like to see a little bit of a change. However, I don't see a judicial review or some appeal process for if it's been expunged or pardoned and then it gets reversed. But if it's some other thing like a discharge, there's no way to get a judicial appeal on that. So I'd like to, I think this is going to the judiciary from here, correct?
Madam Chair, it's,
Is it-
the
sorry.
General Register, Representative Bliss. I guess I'm trying to think through, I mean, currently, if somebody has a conviction that causes them to be prohibited from possessing under Minnesota law, I'm trying to think about the circumstances. You were saying a pardon. Is that what you're referencing?
The way well, I've been reading laws, and I'm not a lawyer, so I got my brain burned today. But the way I read it, there's no, unless it's been a pardon or expunged, for somebody to petition to get their rights back. And there's other ways, you know, and a criminal conviction can be discharged, you know, under certain circumstances. Like you go through counseling or pay a fine or something like that. And there's just no way to appeal through, to get your rights back is what I'm getting at.
So, Chair Pinto, if
yeah,
it's
thank
okay,
you.
can we
Please, yeah.
defer to nonpartisan? Mr. Johnson. Oh, Mr. Devo.
Madam Chair and Representative Bliss, this is federal law, and so we, excuse me, the state's already incorporated this into their statute, and they have a process where it only refers to expungement and pardons. And so the federal law imposes a lifetime firearms ban for these qualified domestic violence offenses. And we already have that in our books. This is just making sure our other statutes track that and don't give misinformation about the length of that firearms disability. So our hands are tied without, by the federal law because it is a lifetime ban, and that standard is there for having your rights restored or having the lifetime ban removed.
Representative Bliss.
Okay, so under 609165, the restoration of civil rights, that I need my eyeballs. Again, pardon me, my brain's fried today. Person's been deprived of civil rights by reason of conviction of a crime and is therefore discharged. Such discharge shall restore the person to all civil rights and full citizenships. That's if it's discharged. The other one, ineligible persons, and I thought, I didn't highlight this one. It has to be expunged or pardoned to get it back. And there is a 672, 713, restoration of firearms and ammunition eligibility. That's for civilly committed person. But you may seek relief through a court. And maybe I'm not explaining this right. I see a lot of confused faces.
Chair Liebling told me my face looked confused in committee today, too, so I guess that's my resting face. I am wondering if the question is, those provisions that allow for restoration or discharge in state law aren't recognized federally? Is that the issue, or, and I could be just totally confused as well. Mr. Diebel.
Madam Chair and Representative Bliss, yeah, essentially correct. So the federal law has their own standard. It's very clear as to what the path is to have this specific firearms disability removed. And the goal of this bill was to incorporate that exact standard so that there was no confusion about both citizens and practitioners as to what the pathway was to have the disability removed.
Representative Bliss.
Well, I was told last week I had some other type of resting face, so I think confused is better than what I had. I guess I'm just confused. I thought that there was a way that you could petition through the state court to get your civil rights restored. And you're telling me that the federal law doesn't have that option. So we're actually removing something that's already there?
Mr. Diebel.
Madam Chair, Representative Bliss, no, the federal law wouldn't recognize the state's restoration of that person's rights. So the person could certainly pursue that path, but they would still be, under federal law, prohibited from possessing this unless they follow the pathway prescribed by the federal statute. So the state court cannot give them relief from this disability under federal law.
Oh, okay.
Representative Bliss.
One more real quick. So this law is not just copying federal or codifying the federal. It's actually making it more prohibitive. Is that correct?
Mr. Diebel.
Madam Chair, Representative Bliss, no, it's, we've already cross-referenced the specific, it's called the Lautenberg Amendment.
Okay.
It was passed in 1996, and it imposes a lifetime firearms ban on certain domestic violence, misdemeanor domestic violence convictions. In 2014, the state referenced those statute, the Lautenberg Amendment statute, in our ineligible person statute. So it's been on the books for 11 years. And so anyone who had these qualified domestic violence offenses would not be permitted to have firearms unless they were expunged or pardoned under existing law. Current, in our statutes now, we didn't at that time, we did not update our statutes, which suggested that persons could have a firearms disability for these offenses based on whatever length the court imposes. That was not at the discretion of the court, because under federal law, they should not have firearms for the rest of their life unless they're restored by the standards set forth in the federal statute, which is incorporated into our statute for the last 11 years.
Representative Bliss.
We don't pay these guys enough.
Oh. Oh, agree with that. Representative Ingen.
Thank you, Thank you, Madam Chair, and thank you, Representative Pinto. I'm just trying to get at the crux of what this bill would do if passed, and I am on board with it from an initial look, but this is a question potentially for nonpartisan again. So under United States Code Title 18, Section 921, it lists off what qualifies as a form of domestic assault that would then trigger this ban. And in Section 921C, it says that in the case of a person who has not more than one conviction of a misdemeanor crime of domestic violence against an individual in a relationship and is not otherwise prohibited in this chapter, the person shall not be disqualified from shipping, transport, possession, receipt, or purchase of a firearm. So is this then extending beyond that current that current code for a singular case.
Representative Pinto.
Well, I'm hoping Mr. Debo could assist me
Mr.
again on
Debo.
that, yeah.
Madam Chair and members, this firearms disability does not require multiple convictions. It's the first-time conviction, and that's always been the case since 1996 under federal law and as incorporated in state law in 2014. So it is not changing the standard that's been on the books nationwide for 20 years and statewide for 11 or 12.
Oh, you're good. Okay. Any further questions? Chair Novotny.
Thank you, Chair Moeller. So, Mr. Debo, what happens to someone that falls between the crack? Under the current law, if someone was convicted of a domestic assault and they had got that expungement, or, they get their rights restored, but so they come into a conflict and the federal courts find out that no matter what, as you said earlier, the federal court's not going to recognize the state court's expungement or release. So what happens to that person if they go through all the processes and then still come into a federal court for charging?
Mr. Debo.
Madam Chair, Chair Novotny, so let me just clarify. If the state expunges the offense, the state offense, or pardons it, then that would meet the federal standard for removing it. It's these other paths that Representative Bliss was referring to about restoration of civil rights. That statute is not the same standard as the pardon or expungement. So if a state court expunges a state offense, then the federal court or federal law would recognize it as expunged because it's appropriate that the state court would expunge it because they're the only one with the authority to do so.
Chair Novotny.
Big subject. And for disclosure, we did spend quite a bit of time last Friday talking through every line of this bill, and it's still confusing. But I guess my final takeaway from this is that, compliance with the federal courts and federal rules is important.
Thank you. Representative Pinto, any closing comments?
Well, I'll thank Chair Novotny for taking that time with Mr. Debo and me. And maybe, I'm realizing that the bill summary, that final paragraph, feels like it's about the best description of exactly what we're doing here and why it makes a lot of sense. So if anybody continues to be confused, just hang on to that paragraph, because I think it'll make it clear. And with that, I very much appreciate the discussion. And yes, particular thanks to our amazing House Research team.
Yes, I'll echo that to our House Research team. Representative Pinto renews the motion to recommend that House File 3350 be placed on the general register. All those in favor signify by saying aye. Aye. Opposed? The motion prevails.